Rest. Hello,
Good
hello.
afternoon, sir. Good afternoon, sir.
Can you hear me? Yes.
Yes, sir.
Um. Now I'm on campus, but the internet. Can we start? Hello.
Yes, sir.
Okay. I'm on campus and I just finished tax, but the internet tax was working. But then when it got to your own turn, there's no. So I'm using my phone again. I hope we don't have the same problem like we had yesterday. Um. So let's So we stopped at what yesterday? We stopped at the registration.
Yes, sir.
If you have submitted your um but I'm sure one of you have submitted now, eh?
I don't know if everybody has
I'm not hearing
submitted,
you.
sir.
Sir?
I'm not sure if everybody has submitted. I don't think it's everybody that has submitted.
But you have submitted. Three people have submitted. Three.
Yes.
I mean, as of yesterday.
Okay, sir.
So let's go to page. Hello?
Hello, sir. You went off, sir.
Yeah, okay. I'm at school now. The internet
Okay,
of
sir.
school has gone off. Now I'm using my phone. And the reason why I came to school was because of you guys. And I just finished
Okay, sir.
tax now at 3:30. And the internet worked. I was able to use Zoom. But now the school internet has gone off. I don't know what else to do. It's like the enemies don't want us to do this class. So let's talk about registration. So I want to know if you are still there. Somebody must be on. Generally, there's
Yes,
no
sir.
legal obligation, there's no legal requirement that anybody must register the vessel. But to register a mortgage, we said a legal mortgage is different from an equitable mortgage, which arises from mere deposit of document. There's no requirement that the vessel must be registered. The mortgage must be registered. But if it is registered, it creates some legal advantages over certain things, except names. So let us look at the process for registration and look at the rights of the mortgagor and the mortgagee. So who is Christabel there? Is what about Phoebe? I've not heard from her since we came back. Is Phoebe there?
I don't think she is, sir.
She's
No, she's
not.
not.
So she's no
Yes, sir.
longer offering this course.
She's no longer offering the course. Okay. So is Christabel there?
She's on.
Yes. We are back again. Hello.
Hello, sir.
Yes. So I said let's go ahead. Let's go to page. Let's go to let's go to the on page 12. So that before the last, so let's write that it gives and the this thing that the right that are please go ahead, please read for us, sir.
Yes, sir.
Are you there? Hey, this yeah. Hello.
Hello, sir.
What happened now? You disappeared again.
No, sir, I didn't disappear, sir. I thought your network went off.
Okay, can we go to the registration and see what we can do today?
Okay, sir. Um, 3.5 registration. There is no legal obligation to register a mortgage, but it is necessary to register in order to give proper legal effect to the mortgage. Where a mortgage on a ship is produced to the registrar at the ship's port of registry, the registrar shall record the mortgage in the register. Section 54, sub 2 of the Merchant Shipping Act of 2007. Any mortgagee who fails to register a mortgage cannot claim any benefits under the Merchant Shipping Act. However, obtaining of priority has been identified as the most important advantage of registration. The date of registration of the mortgage governs the ranking of one mortgage against another mortgage. Section 57 sub 1 of the Merchant Shipping Act protects the mortgagee against all other secured creditors of the ship owner against all unregistered mortgages. Failure to register a mortgage does not render the transaction void, but precedence is given to the later registered encumbrance. Registration gives a mortgage priority over one earliest unregistered mortgages, whether or not the mortgagee, the prior mortgages had knowledge of them. Later registered or unregistered mortgages, unregistered debentures of earlier creation, even though the mortgagees know of them, additional advances subsequently made under a prior registered mortgage.
Yes, I'm listening. Go ahead.
A mortgagee of a registered mortgage does not, however, have priority over one, mortgages registered earlier, two, maritime liens, whether earlier or later, three, any claim in connection with which the vessel had already been arrested at the time when the mortgage had been entered into. Four, any mortgage entered into under a certificate of mortgage, where notice of the certificate of mortgage appeared on the register at the time when the mortgagee entered into his mortgage. Five, any possessory lien of a ship repair. See
So,
Fletcher versus City Man.
yes, if what the effect of registration, if a person has a legal mortgage and he has not registered, the legal mortgage is still good, but the one that is registered before registered. However, the legal mortgage, the written mortgage, is still superior to the registered. But if, let's assume there's a first mortgage and then there's a second mortgage. There's first mortgage, mortgage number one, and then there's a second mortgage, mortgage number two. If after taking money under the first, that's the ship owner that is borrowing money, takes money again from mortgage, goes to take additional on top of mortgage one. So he's taking additional facility. Maybe in the beginning he borrowed 1 million for mortgage one, and then borrowed 1 million for mortgage two, and then maybe borrow another 500,000 on mortgage.
Hello, sir.
The new facility
Hello, sir.
is the second mortgage. Now, if a second mortgage wants to foreclose,
Hello, sir. Your network is breaking, sir.
second Hey, shit. I'm talking to myself. The internet is not. Are you back?
Hello, sir. Yeah, we just started hearing you now. We lost you a couple of seconds, like 30, 40 seconds ago.
Are you there?
Yes,
I
sir.
can. The reason why I came to campus is to use the university internet. It has just gone down. It's not working at all. I'm using my phone, and the internet on MTN is not good. So what I was saying is that if a junior mortgage wants to foreclose over the senior mortgages, the junior mortgage must either get consent of the senior mortgage or get an order of court. Again, what the law is saying is this now. A legal mortgage is good. There's no requirement for the mortgagee of a legal mortgage to go and register. So if I'm the owner of a vessel and I go to borrow money from First Bank, there's no obligation of First Bank to go and register. But there are advantages for First Bank, so that First Bank can get priority, because the first to register gets priority in Nigeria. However, if the holder of a legal mortgage fails to register, the legal mortgage is still binding on the mortgagor. The only thing is that the holder of a legal mortgage who fails to record will lose his priority to the second mortgage that registered before him. Are we together?
Yes, sir.
Okay. However, there's some interest that the legal mortgage, even the one who has registered, must take cognizance of, like liens or previously claims upon which the ship has been arrested. So the legal mortgage must take is not superior to those liens, or what we call liens, L-I-E-N. Okay, so please continue.
Okay.
Hold on, please.
Mortgagors. Okay.
What can I do for you?
Okay, sir.
I'm not submitted. Go ahead, please.
Mortgagors' rights and obligations. The rights and obligations of the parties are governed by the term of their contracts. The following covenants constitutes the mortgagor's obligation. 1. An obligation to insure. The mortgagor has an obligation to insure the vessel against the physical loss of or damage to the mortgaged ship, third-party liability for collision, general average contributions, and other losses. The mortgagor must regularly pay all premium and comply with insurance warranties. The reason why the mortgagor must insure is simply because it is the mortgagor who is declared to have an value of the property. Where the mortgagor fails in discharging this obligation, the mortgagee can insure the ship and charge the costs onto the mortgage debt, providing that right of the mortgage to insure is expressly stated in either the mortgage deed or collateral deed. See the case of Colonial Mutual General Insurance Co. Limited against ANZ Banking Group, New Zealand Limited. Number 2.
Okay. So the first obligation of the mortgagor, the borrower, is to insure the vessel. Why? Because the vessel is going on sea, on high seas, and there are always risks of losses, either accident or wreckage or sinking or whatever. So the mortgagee, the bank, wants the vessel to be insured. Okay? And generally, when the vessel is insured, it's in favor of both the owner and the lender. So the borrower will be the owner of the vessel will be the one that will be insured, but it will now give a right of assignment of the payment in the event of a loss to the mortgagee, to the bank. But the mortgagee too, because he has an interest in the vessel, so that if there's a loss, he can recover. The mortgagee will make sure, will be monitoring, so that the mortgagee will insure the vessel. If the mortgagor fails to insure or to pay the premium, the mortgage premium, and then get to make sure that the insurance doesn't lapse, and then it will get compensated the money he has paid, because the right to pay by the mortgage must also be protected either on a collateral deed or in the mortgage agreement. So the mortgagor must make sure that the lease, that the sorry the
Hello, sir.
the mortgage doesn't go, make sure that it keeps the insurance constant, existing. Otherwise, if there's an accident or a loss to the vessel, and the vessel has what do you call it, has gone into, has defaulted in paying the mortgage, then both of them will lose. So what happens is that the mortgagee, the bank too, will make sure that the thing is kept, the mortgage is kept in constantly in at the ship that also. So let's go to the second element.
Yeah. An obligation to maintain the ship in good condition and repair. Being in possession of the ship, the mortgagor has an obligation to maintain the ship in good condition. The purpose of this covenant is to ensure that the security is not devalued by deterioration of the ship. The mortgagor has the obligation to ensure that the mortgage ship does not breach any of the provisions of the International Safety Management Code, ISMC, which may lead to its detention. The mortgagor must keep always in class the following class recommendation
By following
class
class.
recommendation for repairs.
Okay, so because the vessel, if it's not maintained, will lose value. Don't forget, it's the vessel that the mortgagor, that the mortgagee, the bank relies on, so that it can realize that's the collateral for the loan. If the vessel is not maintained, if you look at section 222 to 249 of the Merchant Shipping Act, there's some standard which the vessel must meet, which is a cargo or a passenger or a sailor vessel. So there's some or an oil tanker. If it's an oil tanker or whatever it is, there's some standard that the vessel must meet. So it's the mortgagor, the ship owner, who is using the vessel, who must make sure that the ship is repaired and maintained, because if it is not, it can be seized for not being seaworthy. And if the vessel is seized, then the mortgagee, the bank that is not using the vessel, stands to lose his money. So the mortgagee he would always require the mortgagor, the conventions. There are some conventions that are stipulated as to the speed limit, the computer, the compass, the number of personnel, everything that must be on the vessel, the repair. So the mortgagor who's using the vessel must make sure that the vessel, the collateral, meet the specification. What's the next one? Obligation to discharge claims or lien. Go ahead. Hello? 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 Hello?
Hello, sir.
Hello?
We can hear you.
Hello?
Hello, sir. We can hear you, sir.
Hello?
Hello,
Is it me
sir.
or
We
Moyo?
can hear you, sir.
I can hear you, sir.
Hello? Was I talking? Hello?
Hello, sir. We can hear you, sir.
Okay. Hold on 1 second. Please hold on. I think the internet of the university is on now. Just hold on 1 second. Don't go. So can you read the next one? Moyo.
Sir, yeah, I think I got logged off.
Yes, now go to the next one.
An obligation to discharge claims or lien. The mortgagor has an obligation to discharge all debts and liabilities which can be enforced against the security, by arrest. If the ship is arrested, the mortgagor must provide security and procure its release. An obligation of legal trading. A ship which is used for illegal trading, such as illegal importation of firearms and ammunition, hard drugs, bunkering, may be arrested and confiscated. The mortgagor should not engage in any of the illegal deals mentioned. An obligation to notify the mortgagee. The mortgagor has an obligation to notify the mortgagee on the movement of the ship.
I'm trying to
This
log into the university. Internet just came on. So, okay, hold on.
Recording. Press.
Are you there?
Press.
Yes, sir.
Yes, sir.
Let me now shut this one. Are you there?
Yes, sir.
Aha. So we're together. So before I got logged off, I was saying that hold on, no. I'm trying to see this thing. I don't want. Okay, before I got logged off, I was saying that there are okay now, so we can all hear. Now the internet is okay, so we can all hear each other. I don't know what happened. Okay, so I'm able to discharge all claims and liens. Okay, so with the first, okay, the first one obligation to insure the guy, the ship owner who is the borrower must insure. He must make sure that the ship is insured so that because the ship is always engaged in perilous navigation over the sea. So if the ship is not insured, there could be accident, there could be wreckage, there could be loss, there could be sinking. If the ship sinks, then the vessel will be lost, and then both the ship owner and the bank, the lender who is not in charge of the vessel will lose out. So the ship owner will always insist that the vessel be insured and kept insured throughout the voyages, so that there will be no loss, there will be no losses. Number two, there's an obligation to maintain the vessel in good repairs, because if the vessel depreciates, the vessel will lose value. In addition, there are many international standards and many international law and many international requirements that determines if you look at section 222 to 249 of the Merchant Shipping Act, that talks about whatever the kind of vessel, the class that the vessel is. If it's a passenger vessel, if it's a commodity vessel, if it's a cargo vessel, if it's an oil tanker, or even if a naval vessel, there are some standards that they must be for international seaworthiness. So if the ship does not meet those standards, it can be seized. If the ship is seized and detained, the mortgagee, the bank will lose money. So it is the ship owner who is using the vessel that must maintain those standards, that must comply with the repairs that are necessary. Number two, there's an obligation to maintain, obligation to discharge liens and claims. If a ship is involved in an accident, okay, or it runs out of fuel and needs to take, fuel from on credit, such, or if they run out of food, okay, or if they run out of drugs or medicine or whatever liability that maybe there's a small accident by colliding with the barge or whatever in the port where they are docking, or something falls out on the vessel, or a person gets injured, those will lead to claims or liens. And those things can rank superior to legal mortgages. So it is for the obligation, it is for the mortgagor to make sure that those mortgages, those obligations are, discharged. Those claims are discharged so that they won't constitute a clog on the security for the mortgagee. The ship owner is in charge of the vessel, so it is for him to discharge those things and make sure that they don't constitute, trading.
Hello, sir. Are you there, sir? We can't hear you anymore, sir.
If the vessel is being used to do something bad, it will affect the interest of the mortgagee. Then the fifth one, obligation to notify the mortgagee. The ship can go as far as Tokyo, Australia, New Zealand. It is for the mortgagor who is taking the vessel that far to notify the mortgagee about where the ship is. Can you take that for us, Muyo?
An obligation to notify the mortgagee. The mortgagor has an obligation to notify the mortgagee on the movement of the ship. This is to ensure that the ship does not sail either in war zones, whence the security will be exposed to a higher risk, or in jurisdictions in which the law may be unfavorable to the priority enjoyed by the mortgage over other maritime claims.
Okay. Don't forget, we just saw now the issue of registration. In Nigeria, it is first to register that will take priority. So if a vessel for another country comes to Nigeria now, and the mortgagee is not aware about that rule, that is forced to register, and it does not register, that mortgagee will lose the right in Nigeria. So the same thing. So that is why it's for the mortgagor to notify the mortgagee about where the vessel he must notify. The next one is what? Obligations with charter parties.
Obligation not to sell or grant a charge on the ship. The mortgagor has an obligation not to sell or grant a mortgage or
Not to grant mortgage.
first discharging the debt to the mortgagee.
Okay, so the mortgagor, before he can enter into another mortgage, he must notify the mortgagee, the current mortgagee, or discharge the current mortgage generally. Okay, that makes sense because there's a mortgage existing. And then let's look at the last one. A charter party, which we do next semester, is where the vessel is chartered. The ship owner can charter the vessel to another person. Although while the ship is being financed under a mortgage by a bank, the ship owner has the vessel and he can now charter the vessel to another person. But the mortgagee must know about it. Okay? So can you read that one for Mr. Moyo?
An obligation as to charter parties. The mortgagor may need to inform the mortgagee before engaging the ship in a long-term charter party in case the terms of the charter party prevents the mortgagee from exercising his rights in care of default by the mortgagor.
So now we have seen all the rights of the mortgagee, of the mortgagor, all the obligations of the mortgagor, the borrower. These are the obligations. So if I ask you in an exam and say, what are the duties or what are the obligations imposed on the mortgagor, you must tell us. Or if I say you are the lawyer to a mortgagee, the bank, and you are asked to draft a mortgage, can you advise your client about what kind of obligation you want to impose on the mortgagor, which will be inserted in the mortgage? You tell us this. So let's look at the right of the mortgagee. The right to redeem.
Yes, the right to redeem. The mortgagor has an equitable right to redeem the ship upon repayment of the loan and the accrued interest. The court will not allow any clog or fetter on the mortgagor's rights of redemption.
Go ahead.
See Fletcher and Campbell against City Marine Finance Limited. However, the court will not intervene if on the face of the contract it is discovered that the ship, notwithstanding that there is an unlawful exercise of power of sale without notice. See the case of Mall. The Mall.
Okay. I'm sure you have done land law. Have you taken land law?
Yes, sir.
And you know what a mortgage is. A mortgage is not a sale, it's not an outright sale. It just creates a security interest in favor of the mortgagee. The mortgagee would hold the security in the vessel, and once the mortgagor is able to discharge the debt, the mortgagee would must release the vessel, the interest that he has over the vessel back to the mortgagor. So it is not, so the right to redeem is an essential term in a mortgage. It is not a sale. It is a right to redeem. There's a right to redeem by the mortgagee, by the mortgagor once it's ready to discharge the money, the debt owed to the mortgagee. So you must know that it's a right, it's not a sale, it's a mortgage, and the mortgagee must always be allowed to redeem. So let's go to the there's a right to redeem, and then the right to take okay, so let's go now to the mortgagee's obligation as well. Mortgagee's rights and obligations. We have seen the borrower's rights and obligations. We want to look at the bank, the mortgagee, the rights and obligations of the mortgagee. So let's go ahead.
Mortgagees' rights and obligations. By virtue of Section 58, Sub 1 and Sub 2 of the Merchant Shipping Act of 2007, the mortgagee is not by reason of the mortgage regarded as the owner of the ship. But if the situation arises for a mortgagee to realize the security, he has owner-type rights conferred on him, but only such rights as are necessary for the enforcement of the security. Number 1, right of repayment. The mortgagee has the right to receive repayment of the principal together with interest at the time stipulated in the mortgage deed and the collateral deed as agreed. The very important clause, usually and expressly stipulated in the deed, is that should the mortgagee at the agreed times, the mortgagee is free to seize the sum owing to him. Where there is a default in the mortgage deed by the mortgagor, for instance, if the mortgagor default, where there is a default in the mortgage deed by the mortgagor, for instance, if the mortgagor defaults in payment, endangers the security in any way, or if the vessel is burdened by maritime lien for an unreasonably long time, the mortgage becomes enforceable.
Okay, so the first right of the mortgagee, the bank, is to be repaid, because that's what he wants under the mortgage. He advanced a loan, he wants to be repaid. And if the mortgagor does not pay, the mortgagee is entitled to enter, take possession, and sell the vessel. Or if the mortgagor does anything that is inconsistent with his right, like there's a lien that is unreasonable long, or he defaults, or breaks a law or endangers the vessel. So any that will affect the right of repayment would trigger the right of the mortgagee to enter possession and take. So the next one is the right to enter possession. Please go ahead. I want us to finish this today.
The mortgagee has no right to take possession of the ship unless there is a default.
Yes. Go ahead.
Or a threat to his security or express contractual provisions. He will be liable to the mortgagor for costs and substantial damages. See the case of the Mano. The mortgagee can either be in actual possession or constructive possession, that is, the seizure of the ship through his accredited representative. Actual possession involves physical seizure of the ship through the accredited representatives of the mortgagee, who may go on board. Constructive possession involves giving of notice of the intention of the mortgagee to take possession to the mortgagors, I don't know what's supposed to be here.
Okay.
Charters, underwriters, and other persons known to be in the sled in the ship. Constructive possession usually takes place when the ship is not within the jurisdiction. It is impossible for the mortgagee to take actual possession.
Okay, so if there's a danger to the vessel, or there's a breach of an agreement along the way, generally the general is that the mortgagee cannot enter into possession because he's not an owner, he's just a banker. But what the law says is that if there are instances when the mortgagee may enter into possession, and that is when there has been some, inconsistent or violation um, of the agreement, the legal mortgage, and then there can be an actual possession of constructive possession. And actual possession involves the physical seizure. Constructive possession is when where it takes place where the ship is not withheld, where the ship is not within the jurisdiction, but the mortgagee has notified authorities, and then it is impossible for the mortgagee to take possession. So where there's constructive possession, that's when the vessel is outside, for example, outside Nigeria, and the mortgagee notifies maybe a lawyer or some other persons there to commence proceedings in that country to arrest or to detain the vessel. So generally, the mortgagee does not have a right to detain or to enter, to take possession. But if there has been some act that violate the deed or that would endanger the vessel, the mortgagee is entitled to seize possession and then commence the action to resale. Okay? The right to freight.
The right to freight. The mortgagee of a ship, by taking possession before the freight is completely earned, obtains a legal right to receive the freight. He has a priority over every equitable charge of which he has no notice, and it makes no difference that any subsequent encumbrance was the first to give notice to the charterers of his charge on the freight.
Okay? So a freight is what is paid under a voyage charter party. So there's a ship owner. Somebody comes to charter, a third party comes to charter the vessel. This is a charterer. The charterer will be paying freight to the ship owner. That's the cost of rental or chartering the vessel. So if the vessel is possessed by the mortgagee, the bank, instead of the freight to be paid to the ship owner now, to now be paid to the bank, to the mortgagee. So that's the right to the freight, because the freight has not been earned and the ship is no more in possession of the ship owner, the mortgagor. The ship is now in possession of the mortgagee. So the charterer, instead of paying the freight, the rental value to the mortgagor, will now be obligated to pay it to the mortgagee, who has now come into possession of the vessel. So there's also the power of sale. Power of sale follows seizure anyway to possession. Once the vessel has been repossessed for non-payment or it has been seized, the next thing that follows is the power of sale. Please go ahead, sir. Is Mr. Moyo still there? He has gone off. Hello? Hello? Am I the one or you are the one? Hello?
Hello, sir. We can hear you.
Okay. Did it go off?
Hello.
Yes.
We can
Nobody
hear you,
said anything.
sir.
Eh? Hello? Are you still there?
Yes, sir.
Yes,
We
sir.
can
We
hear
hear.
you.
What about Moyo? Did he get locked off?
It's like it was locked up, sir.
It seems so, sir.
Okay. So where's Christabel? Okay, who was the other lady that talked now? If Christabel is not there, who was the other lady? Eh? Is it that nobody wants to talk? Or no, people don't want to answer me?
Good evening, sir.
Who are you now? Talk to me now. What's the name?
It's Faith, sir. Faith,
Eh?
sir.
Faith.
Faith, yes, sir.
Faith.
Yes, sir.
It's different from Phoebe.
Yes, sir.
Okay. So can you take off from where Moyo left?
Okay, sir. Actual possession in right to Faith.
No, we finished
Should
right
I
to
start
first.
from the beginning, sir?
No,
Oh,
we
okay.
finished right. So you are not even part of, or you are not listening.
No, I was, sir. I was
You are
listening,
not.
sir.
Why are you talking about right to first? Okay, go ahead.
Okay, sir. The power of sale of the mortgagee is statutory and contractual. Under the Merchant Shipping Act 2007, with the consent of the minister, every registered mortgagee shall have power absolutely to dispose of no person than one registered, a mortgager of the same ship or share. A subsequent mortgagee shall not, except under the order of a court of competent jurisdiction, sell the ship or share without the consent of every mortgagee. See Section 57, Sub 2 of the Merchant Shipping Act 2007. However, in exercising his power of sale, the mortgagee is not a trustee of the power of sale for the mortgagor, but the mortgagee must act bona fides of realizing his security and must take reasonable precautions to secure a proper price. See Cockmere Brick Co. Limited against Mutual Finance Limited and the case of Farah against Farah Limited.
Okay.
Should I continue? Okay.
Yes, continue before I come in. Yeah.
Okay, sir. Appointment of receiver.
Okay, hold
In the
on.
face
Before you go
of
to hold on before you go to appointment of receiver. So the mortgagee, the right to sale is generally in this, is a statutory right which the mortgagee has. It's in the statute. Okay. So the right to sale is in the statute which the mortgagee will have in the statute. However, as we have noted, there are two things. So once the mortgagor has defaulted, the mortgagee is allowed under to sell because there's a right both under the agreement, under the contract, and then that is provided under the statute. However, if the mortgagee is a junior mortgage, as we have said, if the mortgage is a junior mortgage, before he can sell, he cannot sell without the consent of the senior mortgage. That's the people who are before him, except with the order of court or with the consent of the senior mortgagees. And then the mortgagee must be very careful after he has foreclosed, after he has sold. It's not a trustee, it's generally not a trustee for the mortgagor. However, the way he handles the money realized from the mortgage is important. So the mortgagee can only take the money that belongs to him and the cost. Whatever is remaining must be passed over to the mortgagor. And the mortgagee cannot be found to be of bad faith. So if I borrow money from First Bank and First Bank wants to foreclose, First Bank will take its money and the cost and give me back what is remaining. In addition, First Bank cannot go and sell to, a director of First Bank. First Bank is obligated to sell at fair market value to, the best purchaser who can pay the highest price. It must be First Bank must be the mortgagee in power of sale, in exercise power of sale, is obligated to comply with the rules and do everything right. So let's go to the appointment of a receiver.
In the face of a deed, the mortgagee can appoint a receiver to collect the income of the mortgage ship and pay all the necessary expenses until the realization of the security. If the deed does not provide for appointment of a receiver, the mortgagee can apply to court for such an appointment. Should I go ahead, sir?
Go ahead.
Okay. Maritime liens and its enforcement.
Oh, okay. Hold on. For maritime liens are, I think he has Professor Lawin taught you maritime liens.
Yes, sir.
Please answer me.
Yes, sir. Yes, sir.
Professor Lawin has taught you maritime liens. Maritime liens.
Yes, sir.
Okay.
Yes, sir. He discussed this. Yes, sir.
So you know everything about that. Do you know everything about maritime liens?
Yes, sir.
No, sir. No, sir.
Before, I want us to finish this area. The time is almost up. So let's go over it again. For the mortgagee, is right. He has the right of repayment. If there's no payment, he can go ahead and seize the vessel. Then he has the right to take possession if there's been a violation, either constructively or physically. Then he has the right to fret. If he has taken over the possession and there's on end, fret that has not been earned, that has not been paid, but to the ship owner, the mortgagor, the mortgagee can collect them. Then power of sale. He has the power of sale contractually and statutorily. But if the mortgagee is a secondary mortgage, he must get the consent of the senior mortgagees or the order of court, and he must observe all the good faith action. And then appointment of a receiver. A receiver will be appointed if it's in the deed, so that the receiver will take over the vessel. So there's a mortgagor, there's a mortgagee. I am the mortgagor, I'm the ship owner. First Bank is the mortgagee. So the First Bank will appoint a receiver. This receiver would take over the vessel and be collecting money from the mortgagee and from the third party. A receiver is a third party who will take over the vessel, or is appointed to sell the vessel or manage the vessel. So the receiver will be collecting money from other people. But instead of paying the money over to the mortgagor, the ship owner, the money will now be paid under the order of the receivership to the mortgagee. So receivership is where a third party is appointed to manage or sell the vessel, and then whatever money is realized will be paid over to the mortgagee. The mortgagee himself does not manage the vessel. It is the receiver who is appointed based on the deed that will now be managing the vessel. Those are the rights of the mortgagee. Okay, now he said there are some rights, so we can quickly skip this, but I just wanted to see them. They are superior to the mortgage, either under the Admiralty Jurisdiction Act or under the federal rules and the federal high court rules. So let's rush through the maritime liens and within next 10 minutes that we have, and then go. Faith, let's go read it for us, please. Maritime liens and enforcement.
Okay, sir. Maritime liens and its enforcement. There are two types of liens in maritime, namely maritime liens and statutory maritime liens. See the case of Mercantile Bank of Nigeria against E.R. Tucker and others, the Bosnia. Maritime lien is a privilege charge upon a vessel, aircraft, or other maritime property in respect of services rendered to or injury caused by that property. It attaches to the property the moment the cause of action arises and remains with the vessel irrespective of who is in actual possession. According to Christopher Hill, it is a right which arises from general maritime law and is based on the concept that the ship as itself caused harm, loss, or damage to others or to their property and must itself make good that loss or damage. In that case, the ship is the wrongdoer, not its owners. It is the instrumentality by which its owners or their accredited representatives do wrong.
Okay, hold on 1 second. Does anybody know why maritime liens are different? So the reason is this: for maritime liens, I'm sure have you done company law?
We are doing it now, sir.
But you know, a corporation is, once it's incorporated, it's separate from the legal owners.
Yes, sir.
You know that?
Yes, sir.
Okay, the same thing with vessel. Once a vessel starts to trade on the IC, the vessel itself is different from the ship owner. So in this case, for maritime liens, it is the vessel that has caused the injury. So the claim is attached to the vessel. It doesn't matter whether the vessel has changed hands. So I might be the owner of the vessel when the accident occurred. Somebody died, somebody lost his hand, somebody was injured. So if I now sell the vessel to Moyo now will be liable. The vessel will still be liable to that claim because it's a lien. Maybe when I owned the vessel, when I was the owner, the vessel was going to Japan. It ran out of fuel or food, and somebody sold the food and fuel to them in South Africa. The money is a lien, it's a claim. It will follow that vessel. Even if I sell the vessel to Moyo, anybody who sold the food or fuel to the vessel can claim against the vessel, even when it's in possession of Moyo. Go ahead, Moyo. Go ahead and let's finish. Let's quickly rush through it.
Section 66 of the Merchant Shipping Act 2007 categorizes the following inventory of claims as maritime liens on the ship. A. Wages and other sum due to the master, officers, and other members of the ship's complement in respect of their employment.
Yes. Go ahead.
Okay, sir. B. Disbursement of the master on account of the ship. C. Claims in respect of loss of life or personal injury occurring whether on land or water in direct connection with the operation of the ship. D. Claims for salvage, wreck removal, and contributions in general averages. E. Claims for port, canal, and other waterways dues and pilotage dues. Furthermore, Section 5 sub 3 of the Admiralty Jurisdiction Act 2004 lists claims for salvage or damage done by ship or wages of the master or of a member of the crew of a ship, or master's disbursement as constituting maritime liens. According to Inform Usoro, maritime lien is inchoate in nature, and unlike a mortgage, it creates no immediate right of property. It is devoid of any legal consequence unless and until it is carried into effect by legal process, by a proceeding in rem. It is further submitted that the claimant must of necessity bring an action in rem against the ship to enforce his claim. A maritime lien is different from the common law possessory lien. Under the possessory lien, the lienee has the right to retain possession of a chattel pending payment of an outstanding obligation for services rendered. Once possession is relinquished, the right to lien is lost. A maritime lien is further distinguished from equitable lien, which does not depend on possession of the thing, but can be lost by a sale of the thing to a bona fide purchase for value without notice. By virtue of Section 18 of the Admiralty Jurisdiction Act 2004, an action on a maritime claims or on a claim on maritime lien brought after 3 years after the cause of action arose will be statute barred, except where a statute has specifically fixed a limitation period in relation to the particular action. For example, maritime lien against a ship arising by collision is extinguished after a period of 2 years. Section 72 of the Merchant Shipping Act 2007 specifies a limitation period of 1 year from the time of cause of action for the maritime liens itemized under Section 66 of the Act. Further to the above, maritime liens can also be extinguished by the payment or satisfaction of the claim, the sale of the ship by a court of competent jurisdiction, lashes, destruction, and total loss of the ship. In the absence of any contrary intention under the Act, Section 67 of the Merchant Shipping Act 2007 gives maritime liens listed in Section 66 of the Act priority over mortgage or any other rights.
Okay, now for our final this thing now. So between our mortgages and maritime lien, which one has priority?
Maritime liens.
Now, if you have a claim in maritime lien and you didn't know after 2.5 years, under what section will you bring your claim in Federal High Court? Under which statute? Time is almost gone.
Section 72 of the Merchant Shipping Act.
How long does it give for you under that one?
A limitation period of 1 year.
1 year.
No, they are wrong. That's what I are saying. Which one you are filing after 2.5 years? Under which statute will you bring your claim? Does anybody want to help her? That's what they are paying you for as a lawyer now.
Section 18 of the Section 18 of the Admiralty Jurisdiction Act.
How many years does that one give you?
After 3 years.
So you can choose. Is how you fashion your claim, and that's why they are paying you. So you will choose under which section you want to. Okay.
The claim. Okay, sir.
Okay. For example, now the Kano State now. You can go to federal because the federal is the APC is considered Federal High Court, NNDP is considered State High Court. The post judge filed his claim under fundamental human rights in Federal High Court, so he was able to go to Federal High Court. So you are the one to fashion your claim the way you want it, so you can go to the court that pays you. So we'll see you on Wednesday, okay?
Okay, sir.
So we go to, is this salvage next?
Yes, sir.
Okay, we see you on Wednesday and go to salvage. So there'll be a question that'll come out on mortgage in exam.
Okay, sir.
All right. Bye-bye.
Thank you, sir.
Those people outside. Come in. Okay, hold on. Who are you? Who are you? What? You? Ademuagun. That's your name?
That's my surname.
That's your surname? Okay, who's your dad?
Father is late.
What's his name?
Matthew Admiralty.
Okay, Bisingo. Wolingo. Are you from Akoko?
No. It's a very big thing. I don't make it.
Okay, I'm talking about the Akoko guys. Okay. You Nko, are you in tax too? You rush this thing. What group are you? What group are you? You?
Sure. I'm the same group.
You are together. Okay, hold on. You're supposed to have submitted this thing to Phillips, not today. And you're not supposed to come to me. No, not today. Not today.
Ninth on the 9th.
Said latest. Didn't say today.
Yeah, that's the latest.
Sir?
Yes, sir.
No, he didn't say today.
That's the latest. On or before 5.
And now, so why do you have to come to the? So that means if I were you, I would come before that day. That's me. Oh.
Yes, sir. All right, sir.
No, I'm not.
All right, sir.
No, you are smarter than me.
No.
I'm stupid. That's what they're telling me.
Sir?
That's what he said. No, he said today. I'm stupid. That's what they're telling me.
No, sir.
Okay, I'm not gonna collect for him. How many copies do you have there? Okay, you're gonna come here. See what this guy wrote? Because I'm very busy. Come. One for me, Professor Sonny Abi. On my own, to you write my name. You now put so that.
Okay.
Hold on. You now put the day you submitted it. You asked for I'm collecting Sonny's copy. I'm collecting my own copy. You will sign the day you go and give the other ones to Phillips. So that if there's an argument, say you came on this day. Okay, I'm not supposed to collect from you. So please, let's do it one by one.
Thank you.
But Zainab,
Yes, sir.
you want to pass this course?
Yes, sir.
You are sure?
Yes, sir.
Okay. Wait. When is Ilya?
I'm not sure, sir.
You are failed.
Linda.
Do you know what you are going to pay?
I mean,
Is you don't want to pass this course.
yeah.
What is she supposed to pay?
Yeah.
Right.
That's if you want to. You don't have to pass it. I'm serious. You don't have to. So you are going to take 2 copies. You write Dr. Bayemi. Then you write your name. The day you submit, you sign. Okay. And then for Professor Sonny, you write Professor Sonny and put Professor Sonny's copy given to Dr. Bayemi. You write your name, the date. So please just take it easy one by one. You know why I'm doing that? I'm a lawyer. People they can form. You know how Nigerian people do now? I saw him. I was the best guy. I know in the name of Jesus. It's a lie. He doesn't know Jesus. So he just wants to get what he wants today. It's just easy now. You just say submitted. You put my own name on top for my own copy. Then if it's person submitted for Sonny's copy, you put for Sonny's copy's name on top. The people just went home and forgot about the course. And outside, they said they want to postpone because they want to be. I was just laughing. You see, people don't submit, they are going to get -5. Who else is a Muslim here? Are you a Muslim too? The guy in my phone.
Yes.
You're a Muslim? No, you're a Muslim. What about the small guy, the young guy at the back? You are denying. What about the old man there? I'm going to check your matric name, matric number now. Wait. Which one is this one? Dr. Bayani. So you submitted what day?
Today,
What day?
9/1/2025. Signed.
Okay, you can go. So it's your obligation now to submit to Phillips. If you don't, I'm not responsible for you.
So thank you, sir.
You understand?
Yeah.
Where is it? Did you write what you're gonna bring is for later?
Yep. I already know it.
No, you have to write and sign. You have to have an agreement.
Thank you, sir.
Thank you, sir.
All right.